Welcome, one and all, to the 14th episode of the Constitution. What Constitution? In today's episode, we will be addressing a fairly narrow topic, and that is the Fourth Amendment's exclusionary rule, its genesis, effectiveness, and alternatives. But before that, let's go to the Department of Irony and Whimsy. I came across a few articles this past week that convinced me that the American culture industry has overwhelmed politics. Washington today can be understood only as a product of show business, not of law or policy. As evidence, just look at the administration's approach to negotiation with Ukraine. It is straight out of the Oscar-winning movie The Godfather. Hand me over some mineral rights as payback for our past help, and maybe, just maybe, we'll think about letting you, we'll help keep defending your country. Maybe. It's a deal you can't refuse. Sorry, my mob language isn't it's failed me anyway. And they closed this gang up on the Ukrainian president by saying this is going to be great for television. That pretty much says it all about what American politics has come to. The world we now inhabit, politics and constitutional government, is really pretty much pure entertainment, and that's coming from the leader, the executive leader of this country. Staying on the theme of entertainment, this past week, America lost what I consider one of the top 5 movie actors of post-World War II, and that is Gene Hackman. So I was wondering what my friends, if they could off the top of their head, what is their favorite Gene Hackman movie from the catalog of the film industry? Friends, let's see. We're going to give Mike some time because I don't know if he knows who Gene Hackman is, kind of stuff. So, Chris, you have a favorite Gene Hackman movie?
Hoosiers, baby.
Yeah, that was too easy.
Yeah, that was mine.
Okay, well, all right, Tim. I expect you to move beyond the obvious here.
Well, pressure's on. I mean, I have two for different reasons. I mean, obviously, Popeye Doyle and French Connection. I think kind of was formative for a certain genre of movie after that. But also, I think his villainous sheriff in Unforgiven is quite remarkable. I mean, one of the great awful lines in all of movie history. "I'll see you in hell, William M. Mooney." He says to Eastwood, and Eastwood says, "I reckon so." So I think I think those two roles are quite remarkable.
Well, I have to mention Poseidon Adventure just because it was the first movie I went to by myself, without brother, sister, or parents, kind of thing, or any chaperone there. But I'm with you on it's either Unforgiven or Crimson Tide. And
Mm.
again, he has this ability to be angry and intimidating, but also have this little grin on his face and a sense of humor in so many different roles.
That's
There.
that's a Mississippi Burning role in that
That same
regard.
thing. Yeah, that's up there too. I mean, I started looking at the catalog, and there are just so many, movies that I enjoyed that he was
Have,
a lead in.
have we even mentioned the French Connection?
Yeah, Tim did.
Okay, good.
Yeah.
That
Yeah.
was one of Tim's. Yeah, there. I mean, and I did. I rewatched Hoosiers. Again, I had to. And again, I love it. The same thing. He can be kind of angry and grumpy, but
He,
you know, kind of stuff.
he
Yeah.
was in the birdcage as well, right?
Uh-huh.
Yeah.
Yep.
And the Royal Tannenbaums.
Yeah, yeah,
Uh,
yeah. Good stuff.
like I said, we start going down this rabbit hole. That'll be the whole program.
I'm gonna throw one more out there. Young Frankenstein.
Yep.
Oh,
And
wow.
he did not get paid. He didn't want to get paid for that.
Little cameo in Young
5
Frankenstein.
minutes, he's the blind old man.
Oh,
who-
that's right. Oh, I forgot.
Yeah,
Yeah.
that's
Yeah.
I don't think
Go ahead, Chris.
I don't think Gene Hackman turned in a bad performance in anything he was in. So
Yeah.
it's hard to say.
yeah.
I told Hoosiers because I wear my IU sweatshirt,
Yeah.
but there's
Oh, it's a tough one. It's such a great list there. So let's turn to another period in history here and find out what the band members think about this day in history. 1933, FDR becomes the last president to be inaugurated on March 4th. Is this a need to know, nice to know, or nuts to know that this is the end of the March 4th inauguration in 1933? Professor Moore.
Absolutely have to know. Because
Whoa, I didn't expect that.
let me think. Okay, I got it. I mean, I remember back in the day when I was in the classroom, kids would always go like, "What the heck? We elect in November and we inaugurate in January? That's the dumbest thing I ever heard of." And my retort was, "Oh yeah, it could be a lot worse. Imagine, if you will."
If it were
And I think there's been these classic moments in our history where the election and inauguration was so far apart that significant stuff happened. Most notably, Lincoln. So I think, okay, I'll back off that it's nice to know, but it's a little more than nice to know, because it's one of those really weird constitutional features, traditions that we have. And so, yeah, I'll go somewhere between, what was it way back, Chris? Mid-major,
Yeah.
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 Between neat and nice. Chris?
Yeah.
I mean, no, Mike. Mike, we'll go with you second.
Yeah, I was trying to see if I can make let me make my need to know argument, even though it's not gonna fall. I think that yeah, you mentioned Lincoln, but if there was ever a presidency that needed those extra few months to sort of get things ready, I think it may have been that inauguration, right? I remember he ran in that election, and he wasn't advocating for any of the sorts of policies that he ends up coming in. And it's
Who are we
only
talking about? You
during
talking about Lincoln or Roosevelt?
I'm talking about FDR, yeah.
Oh, okay.
And it's during that period after the election until March where things are just getting worse and worse and worse, and he has to rethink. And it gives him some time to come in. And I think, isn't the first thing he does is kind of like the bank holiday? Is that
Yeah.
one of his first things? So, okay, seriously, it's nice to know, but I do think it played an important role in that election.
Chris.
It's nice to know. It's not a need to know, but I think and I would agree with what you guys said, but I think it's nice to know in the fact that it shows students the changes in technology. Really, it shows an advancement in society that we can move quicker, we can get from place to place easier. So I think that we don't need that extra time, right? That for that inauguration, because if you think why that's there, part of that is just simply infrastructure and being able to go from one place to another for a person that got elected to get his life together to move it to the White House. It took a little bit more time. Not to mention the fact that, it's the one day in the calendar that tells you to go out into the world. March 4th.
I'm sorry, I'm slow today. What do you mean?
It's the one day on the calendar that tells you to go out into the world. March 4th.
March 4th. Okay.
Just call me
if
Voltaire.
if we ever did like blooper and outtakes,
that would be one.
Yeah, I mean,
well done, Dad.
Lafayette didn't say that, did he?
I think Lafayette
no,
did
but
say
I think
that.
the Whigs in British Parliament did.
No. Or was it Voltaire? It's so hard to keep all this straight.
Well, I think Voltaire said it's when your cheese slides off your cracker.
Okay, let's focus, gentlemen. Let's focus here. Well done. Well done. And again, I think it's close to need to know, because it's really the only time in class that you then have to explain why it was in March. I mean, there's really no, why you're going to talk about it, but now you come to the change, and and so the question is, well, why did they do it in March to begin with? And you get to the infrastructure and the whole change there. So that's why it might be close to need to know there. So it's now time to turn to our discussion on the Fourth Amendment and exclusionary rule from our own, and we'll start from our own legal counsel, and that is Professor James Michael Williams. Beyond his own fame as an athlete and an academic, Professor Williams is also well known in the Bay Area for having the most prolific move moves on the field of play as a San Francisco Giant ball boy. I don't know if you can find it on social
It's
media.
bald. It's bald dude. It's
Oh,
not
ball
ball boy.
dude.
It's bald
Uh,
dude.
and it was like 20 years ago, Mike. You can clarify on that. But if you get a chance, you will understand how he was chosen all county back in high school with his great athletic moves as a ball dude, falling over backwards, trying to get out of the way of the player. You still have it on tape, right?
I don't think I do. I think it's gone. Yeah.
Well,
You're lying.
you can
You're
never go to your
lying.
parents'
No,
house without your dad
you
playing
know,
that.
no, it was on my dad's um TV. He was on his TV. And when he passed away, like we didn't get it off. So it's gone.
Oh, darn.
Yeah.
Darn. I actually looked. I looked on YouTube to see if there was a chance. There's a bunch of bald dude things on there, but I don't think they go back that far.
Yeah. No.
It was classic, gentlemen, if you haven't seen it. So, Professor Williams, let's talk about the Fourth Amendment. One of the founding principles of American due process of law is found in the quote by Sir William Blackstone that better 10 guilty go free rather than one innocent be falsely imprisoned. What is your response to this axiom? And from your observation, do you think most Americans agree with
Yeah.
Blackstone?
Well, we've already mentioned my father, so this is another good time to mention him because in addition to being a bald dude, I was the son of a criminal defense attorney. So I have a lived experience being brought up with that phrase meaning a lot. And even before I got to law school, I thought it was a super important cultural legal norm that made America America, right? Um, Now, upon studying this and thinking about it, we give the government a tremendous amount of power through our criminal trials. And I think that the notion of that statement is if we're going to give the government the power to literally take away our life and our liberty, that they better get it right, which is why the standard is reasonable doubt, which is why that norm, I think, is in our cultural lexicon. Now, do I think that most Americans believe
Well,
this? Oh, go ahead.
you're a professor. I mean,
Yeah,
I gotta assume, even though your specialty is comparative, that you talk about due process both in America and abroad.
sure.
Just from your own experiences as a teacher in the classroom, do most of your students, do you think, buy into this?
Yeah, I think at an abstract level, I would say, yeah, I would say they do. Um, and I would say at a very personal level, some may, right? If there's anyone in my class that has had any run-in with criminal justice system, they're going to have an attitude where they're going to be that way. And at the abstract level, I think it's in that in between where like Tim likes to say, context is king, right? I think that you see the way that well, you see the things that I think a lot of Americans allow the criminal justice system to do, where I think due process rights are being violated. I mean, it's it's happening right now. It's happening right now. And there isn't like there's throngs of people in the streets on this issue. Or it isn't like even politicians are bringing up this idea of making sure we get the right people before we deport them, or making sure due process is followed before you fire someone. I know that's different. That's a civil, but it's still the idea of due process. So I'd say it's complicated, Dave. I'd say that at the abstract level, I think we would say we believe it. I think though Americans are prone to when they get scared, when they think that there's high crime, or when they think that there is something that they need to be protected from. Um, Very quick to see the due process rights go away for others, right? For others, as long as it's not going to affect them.
Yeah, in my over 30 years now, I taught high school, but this would be my beginning of Unit 5 due process unit would be this question. And I would say it was probably 80% just thought Blackstone was full of crap. And their
Well,
argument was, are you you'd let Manson go? but then you turn that around and said, well, you be the innocent person that gets falsely accused and served in, prison for 20 years. I mean, you're right that context is
Yeah.
king, but I found it in the community that I taught in
Yeah.
for overwhelmingly over 30 years, the overwhelming majority of students disagreed with Blackstone. Chris or Tim, thoughts?
I've had students that have, when we talked about due process, that have been through due process. And so that Mike's issue with the abstract versus the reality is pretty interesting, because I've had some kids say, Mr. C, that's really not how due process worked for me, because having been through the system. So that abstract nature of it is great in the warm, comfy, cozy classroom, but when you're up against the car and the police are patting you down and you're thinking about you may end up your young life maybe in jail, then due process takes on another thing. But I have a lot of students, David, like you said, that have echoed the idea that I've got nothing to hide. What do I care if someone searches my place? And so I said, well, let's talk about James Otis. Let's talk about the Five Knights case. Let's go back in history, about there are certain places maybe the government doesn't belong, to get them to understand certain aspects of the Fourth Amendment.
So, Professor Moore, moving on from the theoretical or the philosophical foundations of due process, many argue that the exclusionary rule specifically is neither enumerated nor implied in the Constitution or Bill of Rights. And for the first 100 years after the Declaration of Independence, no court in America preached or practiced any type of exclusionary rule. What antecedents in colonial history could it be argued lay the foundation for the exclusionary rule? I'm trying to figure out where this sucker comes from.
Well, it's certainly not enumerated. And I might argue that it may not even be implied. I think it's more of an enforcement mechanism than a rights issue. But I also am willing to suggest that may not matter, in the sense that, and Mike kind of hinted at this, we have, well, in my estimation, we have an evolving developmental system of law. So, and by the way, there's nothing in the colonial era that's like this. There is nothing. In fact, well, sort of. There's this statement, and we ran across this weekend. We were doing a conference at our organization, and one of the participants pointed out an interesting little clause in the Pennsylvania Charter of Liberties, as well as the Massachusetts Body of Liberties. In the Pennsylvania Charter of Liberties, there's this statement about it's XXVI 26, that you cannot, that if it's almost like a proto-exclusionary principle, that if you're found to be a liar in a trial, your testimony in any subsequent proceedings in any court in that jurisdiction is excluded. So there's this liar clause that excludes you as a witness. Now, is that exclusionary rule of evidence? No, but it's kind of there. In the Massachusetts Body of Liberties, there's almost this exception clause. Like, we'll probably, I don't know, somebody, I would hope, get to all the 30 exceptions that there are to the needing a warrant for searches now. But in the Massachusetts Body of Liberty, it says no conveyance deed is valid if gotten by illegal violence, threats, or forcible compulsion. Now that's interesting. Now. So it's kind of there, but not really in the colonial era. But ultimately, I think the question is it valid if you assume an evolutionary system of law? Is this in line with that development of due process? And I think the enforcement, as I understand it, the original logic was it was to enforce, due process in terms of searches. So I don't think it's there in the colonial. I mean, in the colonial era, there's tons of charters and constitutions where this idea of, well, fundamental to all this is an adversarial system. And in the Anglo American system, there's all these things that develop because it was an adversarial system. You have lawyers, they object. They object. The evolution of not allowing hearsay, the evolution of credible witnesses. So there's all kinds of things in the evolution of due process that are kind of barriers, safeties for the accused. But it's not really there. And Chris mentions one of the most pivotal things in our colonial revolutionary experience is Otis in his essay on writs, which is quite remarkable. Unfortunately, John Adams is the only person that actually recorded what Otis said in court when they were protesting these open-ended search warrants that were issued. And by the way, those writs were issued for like the entire 1700s. And so the most recent iteration is the one that Otis is speaking about and protesting in a court of law. It's a really remarkable speech. And interestingly enough, according to Adams, he's the only person that says this, that Otis, when he was making this argument that this is unconstitutional, he makes a natural law argument. In addition to arguing the common law, the Castle Doctrine, and Chris mentioned Five Knights, but this Castle Doctrine, but Otis takes it a step further and said this is a violation of man's natural liberty, which I think is remarkable because this is 61. This is the early 1760, where very few people are arguing in courts natural law. So that's where now there are some historians that are taking Adams to task that maybe Otis didn't use that argument. But to me, that's fascinating that according to Adams, that was a part of Otis's argument that these searches violate a natural law principle. And again, if you want to, and natural law is open to all kinds of interpretation, which may mean the exclusionary rule is entirely consistent with that liberty principle within that.
So it would be fair to argue or to make the point that you would argue that this is pretty much a judge-made rule. All right.
Yeah. Yes.
And it's really born out of a practical reality of, okay, here's the language of the Fourth Amendment, but and again, we're just seeing the emergence of a modern criminal justice system in 1914 when Weeks is decided, which establishes this at the national level. And so this is kind of born out of a practical necessity of how do you make this language of the 14th Amendment have some practical reality? Is that kind of where you're at? There's no
I think
historical.
It's an evolution of suspicion of government, and on the front end before you even get into court. So I think it's entirely consistent if you believe in the principle of an evolutionary developmental system, and it kind of corrected, as I understand the Weeks case, it kind of corrected a problem that was occurring with police not going through the proper hoops and getting their warrants. So it was a corrective due to abuse.
So Professor Kavanaugh, oh, go ahead, Chris. I'm sorry, Tim.
I was going to say something about Otis, but I do think it's an evolutionary process. You can go back to really, really early colonial charters, like Tim mentioned, Massachusetts Body of Liberties. It is a process, but I would say that, Otis's arguments in 1761 against the risk of assistance cases, it really is kind of in a way, it is an early on exclusionary rule because the government should not have this power to go into these places without the proper warrant. So that evidence that's obtained should not. In a way, I think that it really is it may be a stretch, and maybe I just like James Otis too much, but I do think that if you squint your eyes, you can kind of see the exclusionary rule there.
Is it a penumbras and emanations, huh?
It is a penumbra and emanation for sure.
So, well, sticking with maybe some philosophical fundamental principles, it seems to me, in preparing for this and thinking a little bit deeper about this than I have in a while, is that one of our fundamental principles is, the idea of beyond a reasonable doubt, and that the Fourth Amendment and the exclusionary rule are directly connected to that. Because if you allow tainted evidence into a criminal process, you undermine the whole reasonable doubt notion, don't you? Or am I off base on that?
Well, I don't know about the reasonable doubt aspect, but certainly back to what Mike said, when you allow a massive entity like the government, whether it be your local county or city or state or even national government, because let's face it, most of these ideas we're dealing with local police, right? We're not talking about the national. I think it tilts that balance of power really out of whack. So uh, I'm sorry, Dave. What was your question again?
Well, again, my thing is, if one of the fundamental principles of of due process and the criminal justice
Right.
is that, again, the burden is one on government, and
Yes.
that in order to deprive you of life, liberty, all right, in the criminal sense, and property, I guess, in the civil sense, all right, it's beyond. Well, I don't want to get into civil because that's all different, but it's beyond a reasonable doubt.
Right.
All right. And I'm wondering, does the exclusionary rule reinforce that principle? All right, of beyond or does it in fact undermine that principle because it allows what might be probative evidence that to establish guilt, but it eliminates that from consideration because the law enforcement may have bent some rules or not follow
Right.
certain process. So,
Well, but I mean, but if the rules and Tim said it, we're an adversarial system, right? And so if the rules of the game are clear, then both sides have to play by the rules. And that means the police and local authorities have to play by the rules, which means that evidence has to be obtained through a legal fashion. Because when that evidence is not obtained through a legal fashion, then due process, as procedural due process, is not being followed. And that tips the scale in favor, whether you're guilty or innocent. That tips the scale way in favor of the authorities. I think
so,
that's a clear violation of due process.
so is it accurate to say that truth is not the end that we're looking for in
No,
criminal justice?
no, no, not in
Facts are
the
not what we're looking for. We're looking,
American system of justice is not like the modern inquisitorial systems that you see in some European and even some Asian societies, right? Truth is not truth is not what is being sought in the American criminal justice system. So,
Well, truth allegedly and theoretically is in the jury box, not on either side of the lawyer tables
Yeah.
or even in the witness box. So
Yeah.
it's I think truth is there. It's just in a different location.
Yeah.
I would push back on that and say truth according to the 12 people in the box, right?
Yeah.
Right. Right.
But is that the truth, or is that the truth that has been spun in the courtroom by people
Right.
by presenting
Yeah.
evidence or introducing perhaps
Right.
tainted evidence, the fruit of the forbidden tree?
I have a quick anecdote about this. I remember my dad telling me he'd get a new client and he'd have the police record in front of him, right? He'd have the report, and person would sit down, and my dad would say, "Before you say anything to me, I've read this report, and if this is the way things went down, you're guilty as hell. There's nothing I can do. But if you tell me that things went down differently, if you give me a different scenario, then we might have a case and I can argue for you. So now tell me what happened." And he would always get the story that was going to get to the truth that he wanted to make in the trial. So yeah, it's not about finding truth, not capital T truth.
well, so Tim, I read the journal article that this is, by Akil Amar, one of your favorite guys. I know you and Chris adore Mr. Amar here. And I was somewhat shocked, all right, by the quote here that according to Amar, the modern exclusionary rule perversely benefits the guilty as such. And it seems to me in reading that, I was going, oh my God, he's parroting the tough on crime people out there that been around for a very long time and delegitimizing the rule. Now, of course, I could be misreading this and misunderstanding the context of him saying this, but I'm wondering, do you agree with Amar on that, that this perversely benefits the guilty?
Well, the tough on it's interesting you use the phrase tough on crime crowd. I think there's other ways to get, we can get tough on crime in other ways. We can have draconian sentencing. We can do bails. There's all kinds of things that we can do to get tough on crime. So I wouldn't put the whole, the whole agenda on tough on crime being rooted in whether you espouse the exclusionary rule or not. Did a little digging. This was hard for me to read through all this legal stuff these past several days.
Good for you. It's good for you.
I don't know. I may need. I have my counselor on speed dial on this one, but there seems to be a mixed answers to that question whether the exclusionary rule benefits the accused or not. I mean, one study done a while ago by a guy named Donald Oakes. I think I had that right. He made the point that the exclusionary rule was only applicable in like 1% of federal cases. And so it's so very seldom actually used in federal courts. Now, the study, I didn't have enough time to look at all the state scenarios here, but
we'll have Chris do that.
Yeah, right. Well, he probably already has. I don't know why you didn't ask him that question, stupid. But because I'm showing my stupidity on this one. But so I think some of the studies don't bear that out, that we need the exclusionary rule to be tough on crime. And like I said, I think there are other ways we could, if you want to get tough on crime, you could do that.
The argument is, and again, I don't know if it's from Weeks, but I know from the establishment of MAP, what I call the tough on crime, they hate the exclusionary rule, and we'll talk a little bit later about this anger and hatred toward the exclusionary rule, what it's led to since Matt went on. We'll talk about that in a minute. So that's what I mean by tough on. To say, to me, to delegitimize the exclusionary rule, reinforces what Amar is saying. And again, am I misunderstanding what Amar is saying to the best of your knowledge?
Well, I did not read that book, so I can't speak to that. I did an interest. This is only anecdotal, but there's a couple of cops that go to our church, and so here I am 2 days ago in the narthex after the service. So I'm asking them about the exclusionary rule, and both of them said, and one's a cop in Milwaukee, and one's a cop in a suburban community here in Milwaukee area. They both said that they think in their experience, the exclusionary rule has made them better cops. So they actually embrace the exclusionary rules because it makes them better, getting all their T's crossed and I's dotted. So,
well, and Mike, early on in our relationship, you were still a student in high school. We talked about this, your dad being a defense attorney, and you had some struggles with that, with some of the people that your dad, doing his job that he defended. So I'm wondering about, and I have a sense that your view of the Fourth Amendment exclusionary rule has evolved since those years of junior, senior year. But I share some thoughts about that. And, as yourself an attorney, not a practicing one, but going to law school and stuff. Yeah.
Yeah, no, I remember discussions around the table about my dad representing people who were accused of doing some bad things, and some questions about how he could do that, how he could be the voice for them. And his point was always, even if they did what they said, that drunk driving, right? My dad represented a lot of people accused of drunk driving. He's like, well, what should the penalty be? Like, should they go to jail for life for that? Like, what's the maximum? And as their advocate, that's what I see my role is, making sure that even if they did it or did a portion of it, that it's fair. And also the fact that my dad had very strong views that this is in the community that you live in now, Dave, like Bakersfield, that the DA at the time would do anything that they could to get arrests and to get, and he always thought they were holding stuff back, or they were always out to like get him and to get his clients. So um, as I went through law school and as I learned more about that, yeah, it became, I mean, if I would have ever practiced law, it would have been some sort of criminal defense, because I have kind of come to believe in the importance of, I mean, marginalized folks need a voice. They need an advocate, and probably someone in a criminal justice system is a one of the most marginalized folks in our society that need that representation. So, and if the police have so much power, as we've talked about, if all you're asking them to do is just play by the rules, and you can't just go in and collect whatever you want on someone and go on a hunt through all their stuff. Yeah, I think that's, I have evolved on it.
Well, and
You know,
just
Professor, go ahead, Chris.
I'm sorry, just to throw this out there for the students, and I know the students will find this in their research when you're diving into this, because as Dave's already mentioned, Weeks. You got to remember in this case, Weeks v. U.S., police searched this guy's place twice without a warrant. All right, so they're searching. It's a warrantless search, and it was not one of the provisions for a warrantless search. They had time to get the warrant, but they used the evidence then that was obtained in warrantless searches after searching this guy's place twice. So that's, to me, that we end up with that fruit of the forbidden tree, because, and therein lies the establishment of the exclusionary rule. So it's important to remember that.
Well, and so let's now turn, partly to, I mean, Tim, and you've mentioned Weeks, and in your analysis, you can include the federal government, but I want to turn kind of to the state governments. And I'm wondering, from your understanding and analysis, how effective, in your opinion, has the exclusionary rule been since its application in Mapp versus Ohio, I believe in 1961? Has it been an effective deterrent on law against law enforcement? Chris?
To me?
Yeah, that's you, Chris.
Oh, I think it has. I think Tim's anecdote that he just shared with us, and these are, I'm not going to denigrate your fellow parishioners, but I would imagine that these are just a couple of your average Waukesha police officers, right?
New Berlin and MP in Milwaukee. Yeah, yeah.
Okay, so these are just, they're patrol officers, I would imagine, or along those lines. So I think it helps our police departments be better. I don't have any quantitative evidence to say that how many cases have been thrown out or overstepped by police officers. And here's something I want to say. I need to get this in because I'm going to forget it. Students, you need to make sure you're checking to see how many cases actually go to trial. I mean, there's a thing here that we're talking about. We're talking about a fair trial. We're talking about due process. All really important concepts, but the overwhelming majority of cases, especially at the state level, the local level, they're done through plea bargain.
Isn't it over 90%?
Yeah, it's like 93%. I think that's fairly close. So we're talking about a minutia, but I think it's, and I understand, I kind of appreciate your point you made earlier, Dave, about Professor Amar. It is kind of interesting for him to say this, because it's like, well, we wouldn't have this rule if the authorities, police officers, always followed the law. But if they're not following the rules of the game, then we need to have another rule that requires them to make sure they're following the rules. And, therein lies their frustration. But I mean, again, back to these officers that Tim was talking about, if their argument is, or their feeling is that, hey, it makes us a better police officer, that's a good thing.
And aren't there enough exceptions for some people to wonder whether we even have?
We're gonna ask Mike that in a minute.
Oh, okay.
But I'm curious about, to Chris's point, when does this arise? When does the exclusionary kick in? Because it's not actually during the trial, is it? That an attorney stands up during a trial, you got a jury, and they say, "Oh, you can't admit that."
Well, that's pretrial. That's part of your pretrial motion because you're going to have your evidence list, and so both sides are going to know what evidence is going to be introduced, and so
Yeah.
therein lie the defense attorney can say, "Wait a minute, we're gonna deal with this," and or back when Mike's story about his father that he's talking with his defendant, and he said, "Well, wait a minute, they didn't do this, or they pulled me over for no good reason, or whatever it may be." So they can, a good defense attorney then is going to say, wait a minute, this evidence was obtained illegally, therefore it can't be introduced. So it's really going to be pre-trial.
Yeah, and Mike, maybe because you went to law school, I'm just curious, what happens if a judge, all right, excludes evidence, but the prosecutor brings it up? As you know, playing as you said, and you're right, there's a book written about the DA while your father was there called Mean Justice, which documents a heck of a lot of shenanigans by our DA here in this community. What happens if the DA brings up the evidence kind of in a haphazard way just to get it on the record?
Yeah, well then the defense attorney hopefully is paying attention, and they will immediately object, right?
Right.
And if that objection is sustained, meaning if the judge says you're right, the judge then orders the jury to disregard what they just heard. And there's there's not a lot of good data on this. I mean, the research on juries is tough to do because of the nature of juries, but we just have to, tap into what it means to be a human being and how, I mean, can you really forget what you just heard? And and if the if it's beyond a reasonable doubt, which is what the standard is, right? It's going to play into that, and so it's tough, but that's going to be the recourse. Now, if a attorney keeps doing that, right, the judge will then either hold that person in contempt, or there's going to be other things that could happen. But you bet, and that's why it's important to have a criminal defense attorney who has not only the knowledge and the experience, but also the time. I mean, so many of these cases are picked up by public defenders that have so many cases open. And to Chris's point, most of these things are being decided like with the plea bargains. So the police, the DA will come and say, "We have all this evidence against your client," right? Well, if you don't have a lot of time to be looking at the file and thinking through, do they really have this, or is there going to be stuff I can exclude in pretrial because I know I can see that they violated something? You can't take it at face value that they just have the evidence. But if you have someone that has 50 other cases on their docket and maybe don't see it, then maybe they make a plea based on what the DA is saying that they have, when it never even then gets to the trial to even test to see whether that evidence was obtained in a legal way.
Well, the public defenders call it meet and plead.
Yeah.
They meet the defendant and they plead the defendant right away based on that. And try this on precise, fellas. Don't think about polar bears.
Right.
Right. But the whole idea, if that prosecutor introduces that, then you also have grounds for a mistrial.
Yeah.
If he's been told prior to the beginning, if he's told prior this evidence is excluded, and he tries to get in through the back door, then as a good defense attorney, then you have grounds for a mistrial.
Yep.
And no judge wants to have to go through that.
Well, and Mike, I'm glad you brought that up. And it'd be interesting to see what kind of studies there are on jury behavior. I can only speak for, my few times in a jury pool or on a jury in the jury room. And my last one was a federal case. And although it was pretty much a slam, and it was it was a civil case, a prisoner suing the guards. So it was more of a civil case, but the evidence still, we were told by a judge at certain times to disregard certain things. But we got into the jury room and multiple jurors. Now I'm not going to disregard that, and so now it's up to does another juror like myself, do I say something to the judge? Hey, these people aren't following what you say, and do you really want to do that kind of thing?
So you're telling us you were Peter Fonda?
Huh?
You were Henry Fonda?
Henry Fonda. I thought about it. I ended up not because, like I said, it was such a slam dunk. I didn't think in the end, if it was a a really difficult case in which we didn't know, yeah, I probably would. I don't think I'd hesitate. But in this one, that wasn't the case. And Chris, you did bring up. Let's just briefly talk about that because I'm wondering these exceptions that you mentioned. I fundamentally believe that the exceptions that the courts have carved out pretty much has gutted the exclusionary rule to the point that it has virtually no meaning because there's so many exceptions. And I don't know, I'm wondering if as a group, I don't know if anybody has memorized all of them. I know like in hot pursuit, well, that's a no-brainer.
I got them right here, Dave. They're
Okay, go
searches
ahead.
made during a lawful arrest, evidence found in plain view, searches made with consent of the person. Also, there's the good faith reliance
Yeah.
on
There's the one that's a problem.
the good faith.
Yeah. Who judges good faith? How do you judge that?
Well, I mean, the scenario you could use is like, hey, I have a warrant to search 123 Elm Street, and we've been having this house under surveillance for a number of, and we believe it's a drug house, and we tell the judge we expect to find meth, some amount of fentanyl or whatever, some illegal narcotics. And so we carry out we get the search warrant in good faith. We execute the search warrant. We go into the address listed on the warrant, and in our normal searching, right, we're going to come across illegal weapons or stolen electronics. Not necessarily plain view, but you're carrying out a search, and so you're searching the entire premise, and you find evidence of other crimes. That's a good faith. That's a good faith where you can incorporate you can bring that evidence to bear against those people then, because you carried out the good faith search based on the warrant that you.
But isn't that coming down to the judge having to determine, all right, whether the police are acting in good faith?
Yeah.
And again, Mike, I think you know this. Defense attorneys, when the court made this ruling, and I can't remember which case it is. Is it an Arizona case? I think it's an Arizona case in which they
it's the Leon case in '84, right?
Right. Yeah. So I know defense attorneys went ballistic
Sure.
when the court made this ruling. All
Yeah.
right. Because their argument was judges are predisposed to lean towards law enforcement. Do you have any thoughts or comments on that?
Yeah, no, I mean, to get to the question you were just kind of asking, I think the evidence shows that, yeah, it's completely, these exceptions have gutted the rule, right? And I think it's interesting just to kind of, so yes, to that, I think that, I mean, it's not, there's other ones that are like equally as bad. There's a one from 2016. It's the attenuation doctrine from Utah v. Strife.
What is that?
Evidence is admissible if the connection between illegal police conduct and the discovery of evidence is sufficiently weak. Right. So, and it's, to me, it's not, this is a little different than what you're asking, but 1961 is where we have like the establishment of this at the state level, and all of the good faith one is a 1984 case. I mean, to me, this fits in with the larger sort of arc we've talked a lot about on this program. Like we have the civil rights period, and there is this backlash that begins in the 70s, and then it's coming to fruition in the 80s. And you can see it in politics. You can see it with Reagan's reforms in terms of narrowing government and attacks on welfare queens. And you see it in the legal environment around this explicitly, right? And it opens the doors for the police to do a lot more arresting and putting people in jail, which is what we see. You watch documentaries like 13th, and you'll see it's in the 1970s and 80s that our incarceration rate just spikes, right?
Mm-hmm.
All this is kind of fitting together. So it definitely had a big impact. Sorry.
I'm not disagreeing with you guys, but I mean, if you think about what happened in MAP, and I'm sure the students will look at what happens in MAP, they're allegedly had a warrant, which they did not. And they're also searching for her son. So when they're actually searching through her underwear drawer for her son, that's not a good faith search. And it doesn't take much to say that's not a good faith search. So these magazines that you found and you want to prosecute this woman for, these magazines would not, you're not really carrying out a good faith search looking for a human person in an underwear drawer in a chest of drawers. So unless your son's Tom Thumb.
Well, and
Interesting.
again,
Interestingly enough, there's a good faith in the I'm going to go way back in the day in the Massachusetts Body of Liberties. I think it's Statement 25. There's kind of a good faith exception. No summons, pleading, judgment, or any kind of proceeding in the court or course of justice shall be abated, arrested, or reversed upon any kind of circumstantial errors or mistakes.
and to me,
Yeah, so
that's
all the way at 41, we've got this quasi good faith exception in terms of court proceedings.
right. Which there's my problem. If we say that you have to follow procedures, the minute you make an
Yeah.
exception, then
Yeah.
we can run wild. And as Mike said, beyond good faith, they've added others. All right,
Yeah.
to the point to where at least amongst the fraternity and sorority of defense attorneys is that this exclusionary rule for the most part has been gutted.
Yeah.
Now,
Yeah.
and go ahead, Mike.
I just want to also point out that, I mean, the counter argument is that, human beings we're going to make mistakes, right? Good, well-intentioned mistakes. And the question is, then where does that burden fall? And getting back to the Blackstone comments we were talking about earlier, we want to think that our system, if the mistakes were made, then we will still give the person accused the benefit of the doubt because that's the person that we think is most at risk. And now the assumption has completely switched, right? We're giving the police the benefit of the doubt on the mistakes they're making, which just erodes the process completely. And I think despite Tim's anecdote from the people he talked to, I think it maybe sets up the incentive to not dot your I's and check your T's, because you know that the system is set up that even if you make a mistake, you can make the argument and you can be forgiven and still get the evidence in.
Exigent circumstances, right? And I'm going to lay out the perimeters of this case.
Inevitable discovery.
Yeah. Well, one of my favorite cases to use with kids, and I think it's King versus Kentucky or Kentucky versus King. So I'm going to, for the students watching this, I'm going to lay this out, and you guys can look up and maybe argue about this before you look up to see how the court decided. So the police had an undercover officer. He's making a buy from a local drug dealer, and they didn't want to blow the guy's cover, so they didn't want to arrest him on the spot. So the purchase was made. The drug dealer, the accused, left the scene. They followed him. They lost him for a second. He went into an apartment complex, and all of a sudden the police came up the flight of stairs and looked down the hallway, and he's gone. But they know he's gone into one of these apartments. So they walk down the hallway, and they're listening and sniffing to see if they can smell, maybe some illegal drug activity. Back in the day, it was illegal, and any activity. And they get all the way down to the end of the hallway, and they go, I think, the door on the left. And they listen, they can hear people, and they smell, and it's like, oh, this smells like the odor of marijuana. This is the place. So they pound on the door and said, police, we have a warrant for your arrest. And they can hear people scurrying like crazy, flushing evidence. And, they just like a bomb went off in there. And so this must be the place. So the police kick down the door, and it's the wrong place. Can they use the evidence of the illegal drugs? I think there's a firearm on the table. Can they use that evidence to charge these people, even though the police created the exigent circumstances by losing sight of their person? So students, it's King versus Kentucky or Kentucky versus King. Look that up, but argue about it first.
Yeah, we won't do it here. And again, another favorite one of mine is the OJ trial. Remember, finding of the bloody glove, they get onto the property. Remember, they have to hop the fence or the gate. And their argument is exigent circumstances because we thought, he could have been a victim kind of stuff there. And that's another, I actually lost $100 on that one with a local judge because I thought there's no way they're going to allow that because they didn't have a warrant. All right, kind of stuff. But again, it tells you what I know and why I'm not a defense attorney or an attorney at all kind of stuff. So Mike, let's wrap this up with the alternative because, and again, Tim's argument, I think, is an argument that's made, is that the exclusionary rule is the only method we have to hold police accountable, effectively accountable, and it actually makes them better at their job. All right. What are the other alternatives, and why are they either as or not as effective as the exclusionary rule?
Yeah, there are some alternatives. They all happen after the fact, though. So, I mean, again, I want the students to really think about um, um, this is a process where your liberty is taken away, right? Your ability to be out in society. And so if the exclusionary rule is not operating, what else could you do? Well, there's a federal statute section 1983. You could sue. You could get convicted and think, no way, they got the evidence illegally. You could sue the police officers and maybe get some restitution from suing. Some, but that's an after the fact, and that's not going to necessarily get your freedom back, right? Now, I guess I should have started. You can obviously appeal. You can appeal the decision to a court, right? And you can try to get a mistrial. You can try to get a new trial. But outside of that, you can sue. Some communities set up independent civilian police boards.
Review, yeah.
Yeah, I didn't do a lot of research on these over the last week or so. I know here in San Diego, we've set one up and it's been toothless. I mean, it's like there's just been radio reports how it's hasn't been able to do much of anything, right? Because they're making recommendations when they, right? That's not, it's like Facebook's new policy with what is it, like community? They're going to have the community censors instead of,
Yeah.
right? Um, you can also, I mean, police officers could be found criminally liable if they did something, right? And if a DA wanted to charge, but again, that's not going to get my liberty back, and that's going to happen after the fact.
Well, there's departmental discipline.
And
You know
there's
how effective that
departmental
is.
discipline. Yeah, right. So those are all sort of other methods of way to because again, students, what's the point of this? We want to deter, we want to deter people from making decisions that are going to uh, put innocent people in jail. How do you set up that deterrence? I think it's clear that the best way to set it up at the time would be to say, you can't use that evidence you got, and now you're not going to get the arrest you want. You know, do it clean or don't do it at all. Well, if that goes away, and you know that the possibility of civil litigation or internal discipline is not going to be there, it's not going to set up that deterrence, and police are going to feel free to do many more illegal activities than they should. But I should say, and I think now I won't speak for all
Wait
of
a
them.
minute, should the police do any illegal activities,
Well,
Mike?
that's what I was going to say, and I was going to say that, like all organizations, there are good and bad people in those organizations. I think for the most part, police, like a lot of other professions, are there trying to do the best they can under very tough circumstances. I mean, think about the hypothetical that Chris just gave us. I mean, those are all through the law books. And if you just empathize for a second to think about what it would be like to go up those stairs, right, and have to make these decisions, right? But there are some bad apples in every organization, and we should have rules to make sure that those bad apples aren't able to make decisions that are going to take away someone's liberty. So.
All right, gentlemen, we've come to the end of our time together on the Fourth Amendment and the exclusionary rule. So let's provide some final thoughts and recommendations. Professor Moore.
Yeah, I would recommend, on your panels, look at some studies. Look at some studies, because you'll find that there seems to be varying results to the study. Is this effective or not? So I think in this particular unit, in this particular question, you'd be well served to look at some of the studies that have evaluated this. That would be my advice.
Professor Kavanaugh.
Make sure you read the piece that's attached to this by Professor Amar. I know it's long, but try and make your way through it. The Fourth Amendment, as you noticed, we didn't even scratch the surface on the case law here. There's oh my gosh, there's so much case law. So when you're looking at these cases, and I know you guys will, the students will, make sure you're looking at dissenting opinions as well, because therein you find some arguments against maybe the majority opinion, and those dissenting opinions, no matter what the case may be, well, they'll probably be good arguments, right? So make sure you're checking out the dissents. And something else to think about too, and Mike didn't mention this, is the concept of qualified immunity that police officers have. We've seen a lot of that written, not necessarily about Fourth Amendment issues, but certainly about other issues. So look into the idea of qualified immunity for police officers and how that may play a role in maybe weeding out some of those bad apples Mike was referring to.
Mike?
Yeah, those are great suggestions. I'll lean into encouraging students to think about stories as well as studies. Meaning, I think that if you can come in, you're going to have to know your case law. You're going to have to know like all the legal dynamics of this. But if you have a story on both sides, police and someone who's maybe wrongfully accused, on how the good faith exception worked in someone's life and what happened to them. I'm trying to think of some good resources on this that I can put into our resources. One for sure I'll put in is Just Mercy, which is a book by Byron Stevenson that's more about the death penalty, but it will give you a window into a first person account of what it's like to do this. So I'd recommend you humanize this for yourself and for your judges as well.
And on the flip side, I would just say this was kind of a love-hate subject when I taught, because inevitably when you got on the Fourth Amendment, you get kids raised, well, I got this cousin who did this, it was this search, and you're kind of, students, I know you know this with We the People teachers, but teachers are not legal professionals. All right. Don't trust your teacher who's going to give you advice about due process of law and stuff like that. Go see a trained lawyer there. Chris, I know, is probably one of the few. All right. I'll qualify that, Chris. Maybe there's a few teachers out there who've also had in-depth legal training. I wasn't one of them. All right. I'd always say go talk to an attorney if your cousin's sister's.
Was your cousin named Vinny? My cousin Vinny?
Kind of thing. And as always, I'm impressed that our friends of here were able to get the Whigs, Lafayette, and Voltaire into the discussion this hour on the Fourth Amendment. So again, we're trying to provide as wide of a net of information as we can. And when we meet next time, we're going to be talking about Unit 6, Question 3. I believe it's the longest question ever written in the history of the We the People program. It starts with a quote by Frederick Douglass, but it really gets into the definition and constitutional understanding of citizenship. So fortunately, we don't read the questions here on the Constitution of American Life, but good luck. I just can't. Part of me, I hope I get to see a video on judges judging this and how long it takes them to read the question. And, and they ask one follow-up time, your hearing's over, kind of stuff. So anyway, thank you, students and teachers. We hope we helped a little bit. Until next time, peace, love, Yogurt Tacos. Bye-bye, bye-bonds.